Oh, 15.
Okay. Did you need a few minutes to talk about it, Mr. Luter? Mr. Johnson.
Should I grab him?
No. I think he does.
Okay. Allison put Bella under her desk.
Oh, she did.
She does like to save her feet. So she doesn't think everybody will her there alone.
I'll play with her a bunch.
Huh?
I'll play with her a bunch.
When we flew with her, I put her with a seat in front of me, and as long as she could see me, she was fine in her walk.
She'll be okay in here as long as she's making noise.
She does.
I'm just saying. She might be quite interested. I don't need a dog pocket on my recording.
She doesn't bark.
I know. Just saying. All right. So as far as the jurors go, did you need a few more minutes to talk to Ms. Bell, Mr. Luter, before we start?
Just a couple more.
Okay. I'm going to step out and use the restroom. I'll be back. Should have drank a little monster.
I told you.
I'm going to step out for the same thing.
What?
I'm going to step out for the same thing.
Okay.
Everybody comfy?
Okay. I'm going to use the restroom.
Oh, that's fine. Yeah, you're good.
Still going to be a couple minutes before we start calling.
Yeah, as soon as I guess we're waiting for Mr. Nunez to get back and Mr. Luter's working some things out. I'm all...
Kind of got a long line for the restroom.
Oh yeah. Okay. You know, Mike, you can let him use that one.
This one?
Yeah.
Okay. Don't drink the water. You need the rest of it.
What's that?
Don't drink the water. You need the rest of it.
That's what happened to me.
Okay. I wonder if anybody wants to be in there.
Is any of ours?
Yeah, the Porteets took off a couple of weeks ago for the summer. They were headed to Louisiana and eventually up into Colorado. They spent the first week at Karcher Cabins,
Oh.
and as they were leaving Karcher Cabin, pulling their fifth wheel, just as they pulled out on Highway 90, the fifth wheel came undone.
Oh no. Oh gosh.
And dropped into the bed of the truck.
No.
But they were stuck in the middle of the highway, blocking the right-hand lane.
Oh,
$10,000 damage to the truck, and $3,000 to the RV.
Well, at least it's well, it was a. Oh my gosh, I'm gooseneck, right?
Yeah.
Well, at least it didn't tear the tailgate off and.
Right.
Most of the damage was to the tailgate, but it didn't come off. It didn't get free.
Is that the
They actually had AAA out there? And they get anything done, and some guy driving a crane just happened to be coming by, stopped me,
Oh, yeah. Wow.
lifted it up.
And she's been called before, right? This isn't her first time going through that.
Well, this is the first time I've seen her.
Oh, no,
So they got it hooked back up and decided, we're not going to Louisiana, we're coming back home. We got back home, and then last Wednesday, I drove in to
and it's
Sierra Vista almost.
and it's Dave, right? Or the
Fred.
Thank you, Fred. That's right.
Sorry.
I've met him a few times.
Yeah. But I drove him all the way back to the scene so he could pick up his tailgate.
That's horrible.
So now they're getting it all repaired and deciding what their plans are going to be.
2, 4.
They usually go away with all the summer.
Seems like the way the gas is.
Well, where we're at right now is we have 2. I'm sorry. I didn't mean to interrupt. I didn't hear. Maybe I need those. Maybe the guy's right, and I need the hearing device to help me out every once in a while here.
When he said that, I'm like, whoa, that's kind of
A little horror there, right?
I guess when you get older, you just say whatever you want.
Yeah, no, it is a good feeling when you hit that age. You got a ways to go.
What age is that? Because I feel like I'm getting close.
I'd say 45 or 50.
All right. Not there yet, but I'll
Okay.
soon.
Yeah.
So right now we're at 2, 3, 4, 5, 7, 8, and 10.
That's what I got.
Oh. While they're discussing, is there any of those that you want to call back, Mr. Nunez?
Yes, number 2. Number 10.
2 and 10 for the state.
And
Okay.
probably, no, that's 2 and 10's fine.
Those are who you want.
To call. Just
Okay.
extra questions.
2.
Was there anybody you wanted to call back, Mr. Loader? You can get some water if you want to, but we'll call you back. We'll call you back in a bit, though.
You're not in trouble.
I hope not.
You had that deer in the headlights look.
Well, everybody's staring at me.
And I was writing down these. They were talking fast on me, though. The jurors, I was trying to write down. Right? They were going.
Can hear something.
Yeah. I don't think we're calling back any of the ones that we. I can't believe that at 35, there's only 6 men.
Crazy.
And
Yeah.
what was number 2's name? I got Rebecca Wilkes, but I don't know if I wrote it down right.
That's correct, Judge.
Okay. Yeah, Mr. Nunez clarified. They were going really fast with their names.
They were.
Yeah. So I know there's a few I spelled wrong on my sheet. Did you have anybody? Are you still thinking, Mr. Lutter? If you are, it's fine. I just wanted to ask.
I don't think anyone specific, no.
Okay, so we'll bring Miss Wilkes back. Okay. Could you ask Mike to bring in Miss Rebecca Wilkes, please? And just record-wise, we do have a listed victim for a current case in the courtroom today too, if you guys did not pick up on that. So,
No, I didn't.
I don't think if we do get to that number, then I'll bring that back up. Somebody who's in your diversion program.
Oh,
Good morning, ma'am. So you get to sit right in the center of the first row. You have the hot seat. Okay, Ms. Wilkes, so the attorneys did have some further questions for you based upon some of your answers previously.
Sure.
Mr. Nunez, would you like to start?
sure, thank you, Judge. How you doing?
Okay.
Good. In the questioning, you had mentioned that you had some family that may have had some alcohol issues.
Right.
And were they active convictions, or did they?
Well, not that I know of. You know, if something happened with my dad when I was young, I wouldn't have heard of it. But,
Right.
no, not that I know of.
In those experiences, do you think that would cloud your judgment in any way in deciding the facts of this case?
You know, that's really a hard one. I feel like I'm sort of surrounded by alcoholism, and I would hope that I could be fair, but it concerns me a little bit.
And the judge let you know the case doesn't involve alcohol, it involves drugs, correct? So removing the alcohol from the situation, do you think you'd still be able to be fair and impartial, or?
Probably.
No question I have.
Okay. Mr. Lutter?
You just said probably. That's a little concerning. It's hard to tell.
Yeah, I'm just trying to be honest. I do have some strong feelings about addiction, for sure, but I would say I would like to think that I can be impartial.
In your history as a OBGYN, I'm assuming you've run into some people with addiction problems.
Yes. Yeah, I did my residency at county hospitals, so there's a whole lot of drugs there.
Do you have any feelings whatsoever about just marijuana in general?
I'm gonna say no.
I mean, it is legal, and as you heard the instructions, it's not illegal to smoke marijuana and drive unless there's a parent. Does that concern you at all?
I'm gonna ask you to clarify the question.
Again, we're looking for an open mind and fairness, and taking the facts of the case, would you be able to separate or make a decision on impairment even though marijuana was involved, if the facts shows that there was no impairment?
Okay. Let me unpack that in my head.
Yeah, it's a hard question.
You confused me.
Oh, good. We're just concerned, can you be fair if marijuana is involved? And that's looking at the totality of the circumstances, all of the testimony.
I'm not sure whether this helps you, but I'm gonna go back to probably.
Okay,
I think so.
all right. That's fair. I have nothing further.
Do you want to follow up with anything, Mr. Nunez?
So I think I hear you saying, basically you're gonna try your best, right? And we all wanna be responsible, and that's what it sounds like you're being by saying probably. So in your honest opinion, you try your best no matter what to be fair and impartial.
That's fair enough, yeah.
Okay, ma'am, if you want to wait outside, please. So we can address Miss Wilkes now? Is there a?
The state is fine to keep her on the panel, Your Honor. She's answered several questions indicating that she can be fair and impartial, and the issues that her family has struggled with, or her family members have struggled with, have dealt with alcohol and not marijuana per se. So in this case, I do believe that she can be fair and impartial given the circumstances of this case.
One more.
Yes, sir.
And is that loud enough, Judge? Sometimes I talk low.
Oh, no, I hear you just fine. Yeah. I know I mentioned my hearing earlier, son. Okay.
I was meaning for the recording.
Oh. I appreciate that.
I have no objection.
Okay, so we will keep Miss Wilkes. The next we need is Miss Harrington.
Harrington?
All right, come on up, Miss Harrington. You get to sit right in the middle of the first row.
Right in the middle. Well, I'm not gonna count the seats on. Okay, here it is, it's right in the middle.
You pass.
Good choice, good choice.
Okay, right in the middle.
So the attorneys had some other questions for you based upon. Oh,
Not
no.
yet, sir.
Yeah, give us a few minutes.
What?
Give us a few minutes.
A couple
Yeah.
minutes.
Okay. So the attorneys did have some questions for you based upon some of the answers previously. So I'm going to let them ask a few questions as we proceed. So Mr. Nunez, when you're ready.
Thank you, Judge. Good morning.
Good morning.
So you mentioned you're a retired from the insurance industry.
I worked in the prosecution.
And what did you do then?
I was an auditor, a government, I worked in the federal department at BP, and so I audited claims,
Okay.
and I audited Medicare claims. And I was there in the same department, and I was kind of like the help desk for everybody.
Yeah, good for you. You also mentioned that you have a previous DUI, I think I wrote down about 13 years ago.
Yeah, I think it was 13 or 14 years ago.
And where was that at?
That was just down the street from my house. I was driving dogs around the block. So it's at Lincoln River Ridge.
Okay. And,
No, I'm sorry. It could have been, I'm sorry. It was in Phoenix, Arizona. It was at like 51st Avenue, Happy Valley.
okay.
I'm sorry.
And you said it was just down the street from your house. You were driving a vehicle, a golf cart.
I was driving a truck, and I felt guilty that I didn't take the dogs for walks, so I took them around the block, and a car pulled out in front of me, and I hit him in the back.
Okay. And throughout that process, how did that process make you feel?
I'm grateful that it was a rude awakening for me. It wasn't fun. I had to spend some time in Tent City, just like 10 days, I think. And I also had a monitor on my foot or whatever for, I think, a week and a half. as far as myself, I was very ashamed. And I did stop drinking in 2013. And I hadn't had a drink in 7 years. And my husband's a wine connoisseur. I've had a few glasses of wine, but it really bothers my stomach. So I figured me and wine don't get along. Yeah, it really bothers my stomach.
Yeah.
So I like to be, sober-minded.
Good. And as mentioned, this was a alcohol-related DUI, correct? And it wasn't involving any kind of drugs or marijuana or anything like that. And with the fact that this is a DUI case focusing on marijuana or THC, would that limit your ability to judge the facts as they're presented to you?
I believe so. I'm a fair person, and I would have to hear both sides.
No other questions, Judge?
Mr. Litter.
Did that experience cause you to have any negative feelings towards law enforcement anyway?
No,
Didn't feel you were treated fairly?
I mean, honestly, they actually took my dogs home, and because my husband's out of town, they actually drove my truck and brought my dogs back in the house for me. And then they took me to do the blood work and all that stuff.
It's okay.
So what was,
You answered.
sorry.
Nothing further.
Dan, did you want to follow up with me, Mr. Mendes?
No, Judge.
Okay, Ms. Harrington, thank you for your candid answers. We do appreciate that. If you want to wait outside again for just a few minutes, we'll get back to you.
Thank you.
Okay, well, thank you.
Is there anybody else who wanted to call back?
I did not, Judge.
Okay. Can you grab a mic for me? As far as Ms. Harrington, then, any move to strike?
No, Your Honor, and again, she's answered that she can be fair and impartial, and she doesn't have any biases one way or another. She actually says she'd wait to make a judgment so she gets all the facts from both sides and then have an open mind to make a decision based on those facts alone.
Okay. Mr. Litter?
I agree.
Okay.
I have no objection.
So what we're going to do then is I'm going to get Officer Colbert over here. We're going to do the musical chairs, and then we'll call the jurors back and see the panel.
Oh,
We need to move chairs.
need more chairs?
Move.
Oh, yes. Now you need to hear. Yeah.
No, we need to get a couple more of those boxes. We're just going to stack them on the back wall and make them like we did last time.
7, right?
Seven.
So first row.
Yeah, we'll leave the first row here for now. All these are going to go outside.
Oh, okay.
You got it.
Oh, it's along the wall, that's
Come on. Thank you, sir. Of course, you can do that. Okay.
You know that, right?
That's what I was telling her. 1 and B.
Is that a beach network?
It got shut down. Sir? Well, these chairs actually hold up all right with the rain. Just, yeah, wipe them down.
I forget, how do we do the tables? Oh, we move the desk like this, right?
Yeah, down there. So we got 7. Perfect. Oh, let's pick up some of this stuff. 1, 2. We're gonna let them move to wherever they want.
Well, I have a question. If one of the jurors does get selected, is her husband able to come in and view? Yes.
Yeah, it's open court, it's fine, just have to
So, might just grab an extra chair. I don't know.
issue, which, what number she is.
No, I was,
You know name?
grab
Yeah, extra chair.
an extra chair.
Yes.
Personal life. 1, 2, 3, 4, 5, 6, 7.
Hey, Dave, you like the caddy corner, right?
Yeah.
Okay.
You can sit here.
Let's get this started.
Gotcha.
And you like it like this. And a little bit of angle. Yeah. As far as the extra person, are you okay with having to sit over here, you think, or I don't know, just spot one?
If he may be able to sit right there at the window, or you good by the door.
I'm fine with it, I'll just make sure he knows it.
Gotcha.
So, we good? Yep. Good, Mr. Nunez?
Yes, sir.
Thank you, Mike, thank you. Stephanie, thank you, Estelle. You're moving some stuff too.
Thank you.
Okay. Is everyone ready for the jurors?
Just take a couple of minutes, 1 second. Sorry, didn't mean to hit you with my dress.
It's too big.
What are you trying to say?
Did you say the dress?
Yeah.
I'm gonna go.
Oh, you have to rescan on it?
Only him.
Oh, the guy, okay. Did you want to go check on Bella real quick? Or? Just drive.
Look, David, I don't have COVID.
We were all gonna start coughing real hard when you got here this morning.
Did you get it again?
No, we were gonna.
Oh,
Yeah. No, we're talking about yesterday. Because we're trying to remember when we had the last juror. He took out, it's like, oh, we had those two.
yeah.
And that one week.
He took out the whole town of Yarnell.
What's that?
He took out the whole town of Yarnell.
Alright. So let me make sure I got my names right. Oh, Bessie, okay.
I know, I couldn't hear you.
Besse. Fendrick. Ostrom. Look, you get this number. I don't know who this one was. I had Diane Sawyers, but I didn't.
Is there a Diane?
Oh, Sawyers. Okay.
There we go.
Are you not calling the criminal?
And the gentleman with the name Caro. Oh, Carol. See, I was.
Yeah, they did
I
it all.
couldn't hear any of them. And I had
You
it
say
written
some
down.
time.
They're still trying to guess.
Nap times.
I can get that one out of there.
Yeah, that's my favorite.
Okay. All right. I think it's good to bring him back in when he's. Is that what he went to go do? I hope so. It's always fun too when you're going through your script and you find your typos as you're talking. If you were following along, you would know where I did that.
You just gotta skip on some.
I was like, wait, I didn't put the extra question on that one.
And as many times as we go over, we always miss something.
Yeah.
Yeah.
Well, I didn't miss anything. I just the typing was off. I would have to Main court, did you tell him?
It's a little bit of room change.
Yeah, it's,
You just stand anywhere.
Yeah.
All right, come on in.
well, it's different.
You can just stand.
Just come in, just stand anywhere, and I'll address everybody. We can just stand anywhere for a second. We're going to read the jurors' names. Come on in. You guys can just make yourself comfy. Okay, keep coming so everybody can fit, though. No. And there you go. Oh, you're okay. I wanted to make sure it got to the right person.
There's still 5 nights.
She has water in your coffee cup? Water?
Just coffee.
Okay, there's my water.
Okay.
Is that it? All right, I'm just going to talk real loud, sir, for Mr. Johnson's sake. Can you hear me okay?
Yeah.
So you don't need the headphones if I talk at this tone?
Well, you're speaking louder.
Okay.
But it's working for me.
All right. Come on in, Mr. Carroll.
I've got headphones here.
Okay. Okay, the record should show that the presence, we do have the defendant, counsel for defense and state, as well as the members of the jury panel. I'm going to read the names of the jurors who have been selected to try this case. When your name is called, just stay in the room. I'll release everybody else, and then you'll be able to take the seats that we do have on the side over here. If you're not selected, make sure that you have signed the paper so that we can indicate your mileage and your participation has been greatly appreciated. I did truly enjoy hearing about some of the things that all of you have done in your lives, and I do find great enjoyment in that. I have a whole concept now what nuclear medicine is now that I did not have before. Okay. The first juror we have is Miss Rebecca Wilkes. Second is Miss Judy Bessie. And my apologies if I do mispronounce names. Number 4 is... I'm sorry, yes, thank you. It was 4. We did lose number 1. Miss Findrich. Juror number 4 is Pamela Ostrom. 5 is Diane Sawyers. 6 is Mr. Rick Carroll. And juror number 7 is Miss Kim Harrington. So the rest of you, you may be excused. I do appreciate your service. Okay, I do have a question. Do any of you own a Jeep? Are you parked at the fire station? Okay, no, not in general.
That was Mr. Johnson, he's leaving it anyways.
Okay. So I'm going to swear you guys in just a second. As far as seating is concerned, we do have the 7 seats over here with clipboards. You're welcome to move those around. I want to make sure as we do this, if you need to move in order to hear any witnesses or the attorneys, you can move the chair around. We have this whole area here to work with. So if you have any question though, you'll let me know that. If you could for me though, could you raise your hand for me? Do you swear or affirm that you're going to give careful attention to the proceedings, abide by the court's instructions, and render a verdict in accordance with the law and the evidence presented to you? Okay, so thank you. If you would like to, please take your seats, and if you do need to move them, you are more than welcome to. Was the gentleman coming in?
He said no.
Okay.
Show him later.
Okay. State ready?
Yes, sir.
You ready, Mr. Loader?
We are.
Okay, is there anybody in the jury who's not seated and comfortable and ready to start? Okay, everybody is ready. So what I have for you is I have some preliminary instructions. You do have a copy of those on your clipboard. That way you can follow along. If there's any time where you may feel that you don't understand the instruction as I've read it, please indicate that to me by raising your hand. I would be more than happy to go over it again. Ladies and gentlemen, now that you've been sworn, I'm going to briefly tell you something about your duties as jurors and give you some instructions. At the end of the trial, I will give you more detailed instructions, and those instructions will control your deliberations. It will be your duty to decide the facts. You must decide the facts only from the evidence produced in court. You must not speculate or guess about any fact. You must not be influenced by sympathy or prejudice. You will hear the evidence, decide the facts, and then apply those facts to the law as I will give it to you. That is how you will reach your verdict. In doing so, you must follow the law whether you agree with it or not. You must not take anything I may say or do during the trial as indicating any opinion about the facts. You and you alone are the judges of the facts. The charge defense. To assist you in considering the evidence that will be presented during the trial, I will now tell you about the crime for which the defendant is charged. The defendant is charged with 281381A1, driving under the influence, which requires proof of the following. On or about the time alleged in the Baghdad-Yarnell Justice Precinct in Arizona, in Yavapai County, the defendant drove a motor vehicle while under the influence of an intoxicating liquor or drug or a combination of an intoxicating liquor or drugs, if that person was impaired to the slightest degree. The charge is not evidence against the defendant. You must not think the defendant is guilty just because of the charge. The defendant has pled not guilty. The plea of not guilty means the state must prove every part of any charge beyond a reasonable doubt. Evidence. You will decide what the facts are from the evidence presented here in court. That evidence will consist of testimony of witnesses, any documents and other things I received into evidence as exhibits, and any facts stipulated to by the parties or which you are instructed to accept. You will decide the credibility and weight to be given to any evidence presented in the case, whether it be direct evidence or circumstantial evidence. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is a physical exhibit or the testimony of a witness who saw, heard, touched, smelled, or otherwise actually perceived an event. Circumstantial evidence is the proof of a fact or facts from which the existence of another fact may be determined. The law makes no distinction between direct and circumstantial evidence. You must determine the weight to be given to all the evidence without regard to whether it is direct or circumstantial. Evidence, statements of lawyers, and rulings. As I mentioned earlier, it is your job to decide from the evidence what the facts are. Here are 6 rules on what is and what is not evidence. 1. Evidence to be considered. You must determine the facts only from the testimony of witnesses and from the exhibits admitted in evidence. Anything you may see or hear when the court is not in session, even if what you see or hear is done or said by one of the parties or by one of the witnesses, is not evidence and must not be considered by you. If you should hear or see anything pertaining to the case outside the courtroom, or if anyone should attempt to speak to you about the case outside the courtroom, please report to me as soon as you can. Lawyers' statements. Statements or arguments made by the lawyers in the case are not evidence. Their purpose is to help you understand the evidence in law. Questions to a witness. A question is not evidence. A question can be used to give meaning to a witness's answer. Objections to questions. Actually, let me rephrase that. I left a word out there. Questions to witnesses. A question is not evidence. A question can only be used to give meaning to a witness's answer. 4. Objections to questions. If a lawyer objects to a question and I do not allow the witness to answer, you must not try to guess what the answer might have been. You must also not try to guess the reason why the lawyer objected in the first place. 5. Rejected evidence. At times during the trial, Evidence may be offered that I do not admit as evidence. When evidence is not admitted, you must not consider it for any purpose. 6, stricken evidence. At times I may order some evidence to be stricken from the record. Then it is no longer evidence and you must not consider it for any purpose. Presumption of innocence and burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. That means the state must prove each element of the charge beyond a reasonable doubt. This is a criminal case. There is a difference between criminal and civil cases. A civil case generally involves a dispute between private individuals, although the state can be a party to a civil case. A criminal case always involves a charge that a defendant committed some criminal violation. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. The plaintiff usually needs to only prove the case by a preponderance of the evidence. This is like weighing the evidence on a balanced scale. There may be some evidence on both sides, and the heavier side wins. In a criminal case, the state must prove the defendant guilty beyond a reasonable doubt before the defendant may be convicted of the offense charge. This is a much heavier burden of proof. The state must prove guilt beyond a reasonable doubt with its own evidence. You must not conclude that the defendant is likely to be guilty if the defendant chooses not to testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant acting with the advice of an attorney. You must not let this choice affect your deliberations in any way. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced the defendant is guilty of the crime charge, you must find him or her guilty. If, on the other hand, you think there is a real possibility that the defendant is not guilty, you must give him or her the benefit of the doubt and find him or her not guilty. Statements of the defendant. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all of the circumstances. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the test for accuracy and truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise. It may also state reasons for those opinions. Expert testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons for the opinions, and all the other evidence in the case. Exclusion of witnesses. The rule of exclusion of witnesses is in effect and will be observed by all witnesses until the trial is over and a result announced. This means that all the witnesses, except the investigating officer, will remain outside the courtroom during the entire trial, except when one is called to the witness stand. The rule forbids witnesses from telling anyone but the lawyers what they will testify about or what they have testified to. If witnesses do talk to the lawyers about their testimony, other witnesses and jurors should avoid being present and overhearing. The lawyers are directed to inform all their witnesses of these rules and remind them of their obligations from time to time as may be necessary. The parties and their lawyers should keep a careful lookout to prevent any potential witnesses from remaining in the courtroom if they inadvertently enter. Rulings of the court. Admissions of evidence in court is governed by rules of law. I will apply those rules and resolve any issues that arise during the trial concerning the admission of evidence. Do not concern yourself with the reasons for my rulings on the admissions of evidence. Do not regard those rulings as any indication for me of the credibility or weight that you should give to any evidence that has been admitted. Bench conferences and recesses. From time to time during the trial, it may be necessary for me to talk to the attorneys out of the hearing of the jury, either by having a conference at the bench when the jury is present in the courtroom or by calling a recess. Please understand that while you're awaiting, we are working. The purpose of these conferences is not to keep relevant information from you, but to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. We will, of course, do what we can to keep the number and length of the conferences to a minimum. I may not always grant an attorney's request for a conference. Do not consider my granting or denying a request for a conference as any indication of my opinion of the case or what your verdict should be. Please do not be concerned with what we are discussing at any bench conference we may have. Please respect the privacy of those participating in the bench conference in order to maintain the fairness of the trial. No transcript available to the jury. Taking notes. At the end of the trial, you will have to make your decision based upon what you recall of the evidence. You will not be given a written transcript of any testimony. You should pay close attention to the testimony as it is given. You have been provided with a notepad and pencils. The court encourages you to take notes during the trial if you wish to do so. Do not let note-taking distract you so that you miss hearing or seeing other evidence. If you do take notes, leave them face down on your chair when we recess. You may use your notes during your deliberations at the end of the trial. Any notes you take are for your own personal use and are not to be given or read by anyone else. Whether you take notes or not, you should rely on your own memory of what was said and not be overly influenced by the notes of other jurors. After you have rendered your verdict, the bailiff will collect your notes and destroy them. Do not be influenced at all by my taking notes at times. What I may write down may have nothing to do with what you will be concerned with at this trial. And I do take a lot of notes, just to give you a heads up, and sometimes it's something I have to do hours from now. So don't be influenced by me taking my notes. Admonition. I am now going to say a few words about your conduct as jurors. I am going to give you some do's and don'ts, which I will call the admonition. Do wear your juror badge at all times in and around the courthouse and at the trial location so everyone will know that you are on a jury. And those are the stickers that you have with your clipboards. Do not do any research or make any investigation about the case on your own. Do not view or visit the location where the events of the case took place. Do not talk to anyone about the case or about anyone who has anything to do with it, and do not let anyone talk to you about those matters until the trial has ended and you have been discharged as jurors. Until then, you may tell people that you're on a jury, and you may tell them the estimated schedule of the trial, but do not tell them anything else except to say that you can't talk about it until it is over. If someone should try to talk to you about the case, stop them or walk away. If you should hear others talking about the case, stop them or walk away. If anything like this happens, report it to me or any member of my staff as soon as you can. To avoid even the appearance of improper conduct, do not talk to the parties, the lawyers, or witnesses about anything until the case is over, even if it has nothing to do with the case. The lawyers have been given the same admonition, so don't think they are being unfriendly to you. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all of the evidence, the closing arguments, and the rest of the instructions I will give to you on the law. Keep an open mind during trial. Form your final opinions only after you have had an opportunity to discuss the case with each other in the jury room at the end of the trial. Before each recess, I will not repeat the entire admonition I have just given you. I will probably refer to it by saying, please remember the admonition, or something like that. However, even if I forget to make reference to it, remember that the admonition still applies at all times during the trial. Questions by jurors. If at any time during the trial you have difficulty hearing or seeing something that you should be seeing or hearing, or if you get into personal distress for any reason, raise your hand and let me know. If you have any questions about parking, restaurants, or other personal matters relating to jury service, feel free to ask one of the court staff. But remember that the admonition applies to the court staff as well, as it does to everyone else, so do not try to discuss the case with court staff. Scheduling during trial. The trial is expected to last for 1 day. We will do our best to move the case along, but delays frequently occur. These won't be anybody's fault, so do not hold it against the parties. Delays usually occur because the attorneys and I often need to resolve certain legal matters before these matters may be presented to you in court, or because I am busy with emergency matters on other cases. The usual hours of trial will be from 8:30 a.m. to 5 p.m. We will break for lunch for 1 hour around noon, and we will take short recesses about every mid-morning and mid-afternoon. And we did cover earlier, if this does go to tomorrow, we would start at noon tomorrow. Order of trial. Criminal trials generally proceed in the following order. First, the prosecuting attorney will make an opening statement giving a preview of the case. The defendant's attorney may make an opening statement outlining the defense case immediately after the prosecutor's statement, or it may be postponed until after the state's case has been presented. What is said in opening statements is not evidence, nor is it argument. The purpose of an opening statement is to help you prepare for anticipated evidence. Second, the state will present its evidence. After the state finishes the presentation of its evidence, the defense may present evidence. If the defense does produce evidence, the state may present additional or rebuttal evidence. With each witness, there's a direct examination, a cross-examination by the opposing side, and finally a redirect examination. This usually ends the testimony of that witness. However, jurors are now allowed to ask questions of the witnesses. If you have a question about the case for a witness or for me, write it down, but do not sign it. Indicate that you have a question and the bailiff will pick it up. Please signal the bailiff for me before the witness leaves the stand. The lawyers and I will discuss the question. The rules of evidence or other rules of law may prevent some questions from being asked. If the rules permit the question will be asked of the witness. If we do not ask a question, that is not a reflection on the person asking it. You should attach no significance to the failure to ask a question. I will apply the same legal standards to your questions as I do to the questions asked by the lawyers. If a particular question is not asked, please do not guess why or what the answer might have been. Third, after all the evidence is in, I will read and give you copies of the final instructions, the rules of law that you must follow in reaching your verdict. Fourth, the attorneys will make closing arguments to tell you what they think the evidence shows and how they think you should decide the case. The state has the right to open and close the argument since the state has the burden of proof. Just as in opening statements, what is said in closing arguments is not evidence. Fifth, you will deliberate in the jury room, which happens to be this room as well, about the evidence and the rules of law and decide upon a verdict. Once you agree upon the verdict, it will be read in court with you and the parties present. Finally, you will be released and discharged and released from the admonition. Alternate jurors. The law provides for a jury of 6 persons in a case such as this. We will select an alternate juror so that if a juror becomes ill or has a personal emergency, the trial can continue without that juror. At the end of the case, before the jury starts to deliberate, the alternate juror will be determined by lot in a drawing held in open court. Please do not be concerned with who may or may not be chosen as an alternate at the end of the case. Remember, the odds are great at this time that any particular juror will be on the final panel. Conclusion to the preliminary instructions. The rules of law I have shared with you in the past few minutes are preliminary only. At the end of the case, I will read to you and give you a copy of the final instructions of law. In deciding the case, you must be guided by the final instructions. Does council have any additions or corrections to the instructions as they've been read?
No, Judge.
Oh, did I say final? To the preliminary instructions as read. Okay. Okay, so is the state ready to proceed?
We are.
Defense?
Yes, Your Honor.
Mr. Nunez.
Thank you, Judge. Good morning. So, as you come to find out, this trial is about driving under the influence. We typically think of driving under the influence as somebody abusing alcohol or a substance similar to alcohol. In this case, that's not the fact. In this case, the defendant was impaired by marijuana. She's charged under DUI to the slightest. And DUI to the slightest can be out of if somebody's asked, and 0 to 100, if you go that you're impaired, and you say 1, that means you are impaired to the slightest degree. You'll hear testimony today from Deputy St. Gelay, Deputy Radford, and also a drug recognition expert, Sergeant Ashby, my apologies. You'll hear Deputy St. Gelay describe her behavior. The initial stop was just for a normal routine traffic stop. They made contact. The defendant then became irate, out of control. She did not want to do what the officers were asking her to do. And because of her behavior and statements to the officers, they then decided to proceed with an investigation for a DUI. You'll see blood results. There was blood taken in this case, and you'll hear the results of the blood that show the defendant did in fact have marijuana in her system. And as for circumstantial and direct evidence, it's correct, the officer did not see the defendant ingesting or smoking or however else you can take marijuana, but all the signs and symptoms were there. You'll hear testimony and see video and body cam of failed FSTs. FSTs stand for standardized, SFSTs, stand for standardized field sobriety test. It's not just something done here in Yavapai County, it's not just something done here in Arizona. These are national tests that have been accepted by the scientific community across the nation. So as I said, you'll see video footage, body cam footage of her showing signs and symptoms during those tests. And as I said, too, blood was drawn and marijuana was found in her system. So given the totality of the circumstances, it is your duty to find the defendant guilty based on the evidence presented to you. Thank you.
Mr. Loder.
Slight correction. It's your duty to find her guilty or not guilty based upon the evidence that's presented to you. This is a case, unfortunately, of an attitude problem. There's no question about it. When you see the video, you'll see that Ms. Bell here was upset because she was stopped for a traffic violation. Specifically, she had a headlight out. She had a headlight out, it was 10:30 at night, she was across the street from her home. There was no observed bad driving other than driving with the headlight out. She was stopped by not one, but two police cars right across the street from her house. And yes, inexcusably, although she feels justified, she did not agree with the officers stopping her for a headlight. And she, in no uncertain terms, let him know that. It's not a crime to be angry. It's not a crime to disagree with a police officer. It's not a crime to not follow their instructions to a certain extent. You have First Amendment rights to say what you believe. You'll hear testimony that Ms. Bell believed that they were overboard, that she was being treated unfairly, and she let them know that in no uncertain terms. And yes, you'll see that eventually blood was drawn, and you'll hear the results of those blood tests. She was given a series of field sobriety tests. When you hear the testimony about the field sobriety tests, take into consideration the location, the time, the area, and the agitated state of Ms. Bell at the time when she's being asked to walk heel to toe, when she's being asked to tilt your head back and close your eyes, estimate time, stand with one leg up off the ground and count to 30 or more. take into consideration the location and the circumstances. Eventually, she was arrested. She was taken into custody. She asked for a supervisor. They didn't provide a supervisor. She asked several times for a supervisor. She tried to call the police department to get other officers out there. She wasn't able to. She was taken out of her car. She was transported right to there, the other side of that door, where she was subjected to more tests. And she voluntarily agreed to take these other tests. So when you hear about testimony that she was uncooperative, she agreed to let them transport her up here into there to have another officer do a whole nother evaluation of her, a drug recognition expert. And you'll hear that expert's testimony. You'll hear the testimony of both officers. I submit to you, it's not a crime to be angry. It's not a crime to smoke marijuana and drive, unless you're impaired to the slightest degree. And I submit to you that after everything is presented, and you think about it, and discuss it, and go over the circumstances, that you will find the only verdict here is not guilty. Thank you.
Okay, so the lawyers do have some stipulations that I am going to read in the record regarding evidence. Please listen carefully and correct me if I need to word it differently for you. There's a stipulated that the blood draw was done correctly in this matter. There's also a stipulation to the scientific examination report, which is admitted as State's Exhibit number 6. We also have the body cam footage from, and these are the titles that are on the USB drive that we do have, is Radford SFT, Radford Substation, St. G paperwork, St. Gelais paperwork, and St. Gelais main redacted as Defense Exhibit 1, and they are admitted without further foundation necessary. Correct, Mr. Nunez?
That is correct, and I also have an edited version of what is on his thumb drive.
Okay. And you have an edited
It's
version?
Exhibit number 7. It's just the portions of the footage that I would like to use.
But they are the same footage?
Yeah.
The same footage?
Yeah, sure.
That would be State 7, admitted without further need for foundation. Everything correct, Mr. Loader?
Yes.
Okay, Mr. Nunez.
Thank you, Judge. This time, the state would like to call Deputy Sangellet.
Okay, come up here, sir. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, please have a seat. And if you could say your name for us and spell your last.
Alec St. Gelais, ST period GELAIS.
Hey, Deputy.
Good, how are you?
Good, thank you. Where are you currently employed?
With the Yavapai County Sheriff's Office.
And how long have you been with them?
Say about 1.5 years now.
At the time of this incident, how long had you been employed by SD?
Let's see, July. So I'd probably say just under 1 year.
And what kind of training have you had in order to become a deputy?
I went to the Northern Arizona Regional Training Academy, NARDA. It's about 6 or 20 weeks long. Through there, you do training on SFSTs. You learn the 3 standardized field sobriety tests, which are HGN, walk and turn, and the 1 leg stand.
And you said you get training on those. What type of training?
So I believe it's like a 3-day course, and you go over the 3 standardized tests, which is HGN, the walk and turn, and the one leg stand.
And so what is HGN? What is the full name for that?
So horizontal nystagmus, or
Horizontal gaze and nystagmus?
yeah, the gaze nystagmus.
And what is that test?
So it checks the involuntary movement of the eyes, which is mostly used for alcohol.
And how do you do that test?
So you have them stand up, arms down by their side. You have them follow, usually I use a pen, have them follow it, the tip of the pen with their eyes only. You check for, equal tracking, equal pupil sizes, lack of smooth pursuit, and if there is alcohol involved, there's an involuntary movement of the eyes, which their eyes go back and forth.
So when you say tracking, are you saying they're following?
Yes, following.
When you say smooth pursuit, does that mean their eye is moving consistently one way or the other?
Yes.
And when you see someone impaired, I believe you just said it kind of bounces?
Yes.
Objection, Your Honor, may we approach?
Yes, please.
He just used the term alcohol.
Do you understand the objection? Okay, should I strike the answer and ask him to re-ask?
Yes.
Okay. We are going to sustain the objection. We're going to strike the answer that's provided by the deputy. And Mr. Nunez, you may re-ask the question.
Thank you, Judge. In your explanation of horizontal gaze nystagmus, you made a comment of moving the eye side to side, correct?
Yes.
And then one of the tests is measuring to see if the test responds smoothly.
Yes.
Is that correct?
Yes.
And if it's not moving smoothly, what is that a sign of symptom of?
It could be a sign of impairment.
You also mentioned a second test that you were trained on.
The walk and turn.
And what is the walking turn?
You have the subject stand, arms down by their side. You have them put their right foot in front of their left foot. You have them take 9 heel-to-toe steps, counting out loud as they're watching their steps. Once they get to their 9th step, whatever foot is planted in front, they keep that foot planted and they take a small series of steps turning around, and they do another 9 heel-to-toe steps back.
And in your training, do you have to demonstrate your proficiency at these?
Yes.
And how do you do that?
So I explain to them, I get them in the starting position. I have them put their right foot in front of their left, arms down by their side. I tell them, do not move until I tell you to start. Once I tell them to do that, I get in that same position and I take 3 9 heel-to-toe steps, and I tell them, now imagine this 3rd step is my 9th step. Whichever foot is planted in front, I take a small series of steps back and then take another 3 steps.
So those are the directions you give to?
Yes, just to speed it up so I don't, do the whole test. And
then I also asked, during your training, how do we know that you're proficient at these? Do they give you tests during your training?
Yes, during our training, they go over with, in the academy, they went over, they, had test subjects that we did it on.
And you also mentioned a one-leg stand. What is that?
So again, I have the subject put their legs and arms down by their side, feet together. I have them pick any leg they want, and I tell them to lift it up 6 inches off the ground and look at your toe and count 1001, 1002, 1003 until I tell them to stop.
And what are these tests, what are they looking for when you're conducting these field sobriety tests? What are you looking for?
To see if the subject is able to, be able to understand, multiple directions at the same time, be able to keep balance, and just show that they're able to operate a motor vehicle without, you know.
And are you familiar with the term divided attention?
Yes.
And what is divided attention?
So it's just them being able to complete multiple tasks while, during the walk and turn. They have to look down at their feet, touch heel to toe, keeps their arms down by their side.
And they have to follow your basic directions, correct?
Yes.
Would you consider driving something that requires divided attention?
Yes.
And if somebody is impaired, that would impact their ability to drive?
Yes.
Now let's go back to May 30th, 2022. Are you familiar with that day?
Yes.
Were you working as a deputy on that day?
Yes.
Do you remember your encounter with the defendant?
Yes.
Can you explain that to me? Well, first of all, do you see the defendant in this room?
Yes.
And is that the same person that you had an encounter with on May 30th, 2022?
Yes.
Can you briefly describe what she's wearing?
So she's wearing a black coat, brown hair, except she has a red and green shirt on, and she's sitting in the back corner of the room.
Thank you. Your Honor, can the record reflect that the deputy has positively identified the defendant?
The record will reflect that the deputy has identified the defendant and did point at the defendant in court.
So on the night of May 30th, 2022, what was your duty that night?
My duty?
Yeah, like where were you patrolling?
So I was down in Congress on 89 and 71. I observed the vehicle with its right headlight out. I conducted a traffic stop. For the first 1 to 2 minutes of the traffic stop, my body cam wasn't on.
Why wasn't it on?
I forgot to turn it on. And once I turn it on, it's about like 30 seconds to a minute for it to buffer up and be able to turn on completely.
Okay. And where did you make this traffic stop?
It was on Highway 89, right before Sunrise Road.
And is that within the jurisdiction of this court?
Yes.
And so you noticed the headlight out. Were you facing them? Like, kind of paint me a picture so I can kind of.
So I believe I saw, I don't exactly remember where I was sitting, but I know that once I saw the vehicle, that it had its right tail light out. I got behind the vehicle and then initiated a traffic stop in the dirt lot right before Sunrise Road off of 89.
All right. So initially you said the headlight was out.
Yes.
Was it the headlight or the tail light?
Headlight.
Headlight.
Yep.
Just making sure. And was it just you?
So Deputy Radford is also, so we pretty much work together. We stay nearby. So if he does a traffic stop, I'll go with him. If I do one, he does the same thing,
And what do you guys do then?
just for officer safety.
And it was at night, correct?
Yes.
So were you both parked in the same spot when you noticed the headlight out on the vehicle?
I believe so.
And then you turned on your lights,
Yes.
got behind the vehicle,
Yes.
pulled it over,
Yes.
and then what happened?
Walked up to the driver's side window, I believe, explained to her why I pulled her over, and then asked for her driver's license. She said she didn't have it with her, it was at her house. During this time, she started becoming very, she was already agitated and angry, and, I tried to get her name, and she just being very irate and upset that I pulled her over a headlight.
And it's common for people to be upset when they get pulled over, right?
Yes, I mean, not the way she was acting, no.
How was she acting?
Just very agitated and angry about it.
I'm going to show you what's marked as safety limit number 6.
Be able to understand, multiple directions at the same time. Be able to keep balance. and just show that they're able to operate a motor vehicle without, you know.
And are you familiar with the term divided attention?
Yes.
And what is divided attention?
So it's just them being able to complete multiple tasks while, you know, during the walk and turn. They have to look down at their feet, touch heel to toe, keep their arms down by their side.
And then follow your basic directions, correct?
Yes.
Would you consider driving something that requires divided attention?
Yes.
And if somebody is impaired, that would impact their ability to drive?
Yes.
Now let's go back to May 30th, 2022. Are you familiar with that day?
Yes.
Were you working as a deputy on that day?
Yes.
Do you remember your encounter with the defendant?
Yes.
Can you explain that to me? Well, first of all, do you see the defendant in this room?
Yes.
And is that the same person that you had an encounter with on May 30th, 2022?
Yes.
Can you briefly describe what she was?
So she's wearing a black coat, brown hair, except she has a red and green shirt on, and she's sitting in the back corner of the room.
Thank you. Your Honor, can the record reflect that the deputy has positively identified the defendant?
The record will reflect that the deputy has identified the defendant and did point at the defendant in court.
So on the night of May 30th, 2022, what was your duty that night?
My duty?
Yeah, like where were you patrolling?
So I was down in Congress on 89 and 71. I observed the vehicle with its right headlight out. I conducted a traffic stop. For the first 1 to 2 minutes of the traffic stop, my body cam wasn't on.
Why wasn't it on?
I forgot to turn it on. And once I turn it on, it's about like 30 seconds to a minute for it to buffer up and, you know, be able to turn on completely.
Okay. And where did you make this traffic stop?
It was on Highway 89, right before Sunrise Road.
And is that within the jurisdiction of this court?
Yes.
And so you noticed the headlight out. Were you facing them? Like, kind of paint me a picture so I can kind of.
So I believe I saw, I don't exactly remember where I was sitting, but I know that once I saw the vehicle, that it had its right tail light out, I got behind the vehicle and then initiated a traffic stop in the dirt lot right before Sunrise Road off of 89.
All right. So initially you said the headlight was out. Was it the headlight or the tail light?
Headlight.
Headlight. Okay. Just making sure. And was it just you?
So Deputy Radford is also, so we pretty much work together. We stay nearby. So if he does a traffic stop, I'll go with him. If I do one, he does the same thing.
And what do you guys do then?
Just for officer safety.
And it was at night, correct?
Yes.
So were you both parked in the same spot when you noticed the headlight out on the vehicle?
I believe so.
And then you turned on your lights,
Yes.
got behind the vehicle,
Yes.
pulled it over,
Yes.
and then what happened?
Walked up to the driver's side window, I believe, explained to her why I pulled her over, and then asked for her driver's license. She said she didn't have it with her. It was at her house. During this time, she started becoming very, you know, she was already agitated and angry, and, you know, I tried to get her name, and she just being very irate and upset that I pulled her over a headlight.
And it's common for people to be upset when they get pulled over, right?
Yes, I mean, not the way she was acting, no.
How was she acting?
Just very agitated and angry about it.
I'm going to show you what's marked as safety limit number